Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Boyle 54 for a motion and action on House Resolution 30.
Chair recognizes the gentleman from Boyle.
Thank you, Mr. Speaker, and thank you to the leader for yielding. Mr. Speaker, today I rise to discuss an extraordinary matter before the House of Representatives and the General Assembly. One of the more solemn and somber duties we have as legislators is maintaining the integrity of the offices that represent our constituents. As the Constitution directly dictates, this includes removing bad actors from office, and the Kentucky Constitution highlights this duty and directly says in Section 66, the House of Representatives shall have the sole power of impeachment, and in Section 68, the governor and all civil officers shall be liable to impeachment for any misdemeanors in office, but judgment in such cases shall not extend further than removal from office and disqualification to hold any office of honor, trust, or profit under this Commonwealth. But the party convicted shall nevertheless be subject and liable to indictment, trial, and punishment by law. On Thursday, January 5th, the gentleman from Jefferson 33 filed House Resolution 11, which directed the appointment of a committee to determine if there was sufficient evidence to impeach Commonwealth Attorney Ronnie Lee Goldie, Jr. At that point, myself and members, the lady from Davis 7, the gentleman from Jefferson 33, the lady from Jefferson 40, the lady from Mercer 55, the lady from Shelby 58, and the lady from Fayette 75 were tasked with reviewing all evidence pertaining to any alleged misconduct committed by Mr. Goldie. And Mr. Speaker, to walk you through the timeline, the first review the committee conducted was an overview of the record from the report and exhibits of the Special Commissioner report from an inquiry commission of the Kentucky Supreme Court. This included roughly 190 pages of electronic communications between Mr. Goldie and a female criminal defendant, and a review of Mr. Goldie's testimony from that hearing conducted by the Special Commissioner. And to be very, very blunt about this, the subject matter of these communications was egregious, but the respondent of this action, Mr. Goldie, said in his testimony that these communications with the defendant were just, in fact, normal procedure for a Commonwealth's attorney's office. These communications involved her ongoing case, and it should be noted that all communication, or the vast majority of that communication, was done without the defendant's counsel being present, even though Mr. Goldie was aware that she was represented by counsel. Mr. Goldie requested photographs as well as videos that were illicit in nature in exchange for actions that he would take in active cases involving the defendant, active cases that he was prosecuting. And he also admitted that he sent her money, sent her $25. This went as far as Mr. Goldie communicating with judges and prosecutors and other jurisdictions in hope for a better outcome for the defendant. Specifically, on 2 occasions, the defendant had warrants for failure to appear in court, one in Rowan County, one in Bath County, and he had those warrants recalled, gave her a new court date, and the defendant admitted that she and Mr. Goldie met in person as well during this period of time, but she gave limited details of those meetings. They met one time in the park, and they met one time in the courthouse parking lot when he got her out of court. She had an outstanding warrant. He told her to lay low until court. When she came to court, she remained in the parking lot. He came out of the courthouse and advised her that he had taken care of the warrant. Mr. Speaker, this committee determined that these offenses constitute a misdemeanor in office. In this context, a misdemeanor does not carry the same meaning as it does in a criminal case. In this sense, it means not only misuse of the power of the office that he holds, but a betrayal of the public trust. As the first article of impeachment states, the committee found that because of the actions that have just been highlighted, that Mr. Goldie engaged in conduct that resulted in a temporary suspension from the practice of law by the Kentucky Supreme Court. And there was also a finding of probable cause by the special commissioner, which was adopted by the Kentucky Supreme Court, that Mr. Goldie's conduct posed a substantial threat or risk of harm to his clients and the general public. And right now, as we're on this floor, because Mr. Goldie is suspended from the practice of law, he cannot carry out his duties of office. And in fact, he does not even qualify for election to the office that he currently holds. After our committee reviewed the evidence, we agreed that we needed some testimony from Commonwealth's attorneys who do this work every day. And on February the 2nd, the committee heard from Commonwealth's attorney Jackie Steele, Rob Sanders, and Brian Wright, and these individuals also serve as members of the Commonwealth's Prosecutors Advisory Council. In their testimony, they commented that until now there had never been a Commonwealth attorney who had been actually expelled from the Commonwealth Attorneys Association. The weight of this action alone was noted throughout the committee hearing, and I believe is worthy of emphasis to this body today. In fact, the association had to change its bylaws in order to expel Mr. Goldie, because there wasn't a provision to do that. Based on the fact that there was ex parte contact with the defendant without her attorney present, regardless of its nature, that was deemed outside the bounds of what we as prosecutors deal with on a daily basis, is some of the testimony that we heard. They characterized the conduct as egregious, and they also noted the vast power imbalance between Mr. Goldie and the defendant whom he was prosecuting, and the quid pro quo nature of his relationship with the defendant, according to these three Commonwealth's attorneys, was clearly an abuse of power of the office that he currently holds. For a sitting Commonwealth attorney to be both expelled from their association as well as being suspended from the practice of law, it's an indication that Mr. Goldie is no longer fit to serve in the capacity that he currently serves in. To execute the duties of a Commonwealth attorney, trust is integral. The citizens have to have faith that the Commonwealth attorney will serve fairly, and when the Commonwealth attorney elects to charge an individual and bring the justice system and the state of Kentucky down upon a person, that it's done in a deliberative fashion and that it follows the law. If that doesn't happen, the system as we know it does not work. The system as we know it fails. After reviewing all the evidence, Mr. Speaker, our bipartisan group of members of the impeachment committee determined that we must take action, and we approved the resolution with the attached articles by unanimous vote of our committee, and recommended to this body that these articles of impeachment be adopted. So at this time, Mr. Speaker, I want to go over each article of impeachment that has been filed. Article 1, Ronnie Lee Goldie was duly elected Commonwealth Attorney in the 21st Judicial Circuit, and during his term of office, he engaged in conduct which resulted in a suspension from the practice of law by the Kentucky Supreme Court, with the finding of probable cause that his conduct posed a substantial threat or risk of harm to his clients and the public. And the order required that he notify all of his clients in writing of his inability to further provide legal services. And pursuant to Section 68 of the Constitution, this is an impeachable offense from which removal from office and disqualification to hold any office of honor, trust, or profit under this Commonwealth is warranted upon judgment. Article 2, that during his term of office he engaged in personal communications with a defendant regarding that defendant's pending criminal cases in the 21st Circuit, and that he discussed these criminal matters with the defendant directly without her counsel being present, and intervened on the defendant's behalf in criminal proceedings. These are inappropriate communications, and actions are a violation of the public trust and constitute a misdemeanor in office. And pursuant to Section 68 of the Kentucky Constitution, this is an impeachable offense which warrants removal from office and disqualification to hold any office in the future. Article 3, that Mr. Goldie requested and received inappropriate personal information from a defendant in the 21st Judicial Circuit as a quid pro quo for actions that he took in his official capacity as a Commonwealth Attorney on behalf of the defendant, and that this is a misdemeanor under Section 68 of the Constitution, and as such warrants removal from office and disqualification to hold any future office. It's my opinion, Mr. Speaker, that any of these three articles, we're taking them together, we have three charges here, but any one of them, just any one of them would be sufficient to constitute an impeachable offense. But I think when you take them together, the case for impeachment is crystal clear. Simply put, these acts committed by someone entrusted to carry out the law cannot be excused. Earlier this week, word was received that Mr. Goldie plans to resign effective February the 28th, but this is not enough. The purpose of impeachment is not just to force bad actors to resign, but it's to ensure that the public trust cannot be further betrayed or even delayed upon that person's timetable that they've set out. To quote the Commonwealth Attorney for the 16th Judicial Circuit, Mr. Rob Sanders, who testified before our committee, if not now, when would you ever impeach a Commonwealth's attorney, short of killing someone or committing another violent physical offense? As far as ethics goes, this is as unethical as it gets. There's no excusing this conduct. It reflects poorly on prosecutors and undermines Kentuckians' faith in the criminal justice system. Commonwealth's Attorney Brian Wright of the 29th Circuit said Goldie, who had an opportunity to respond to our committee in writing, his characterization of that response was that it was attempting to somehow explain away his conduct, and the conduct is just simply inexcusable. These are terrible, awful allegations, and I don't see how he can stay in office. I don't know how there could be a reasonable explanation for this. And to this body, I ask the same question: when is enough enough? When will we draw the line? Will we send a message that this kind of conduct is simply unacceptable? And, Mr. Speaker, I think I probably needed to have the clerk report House Resolution 30. I don't think I did that, so would the clerk please report House Resolution 30.
Clerk, please report House Resolution 30.
House Resolution 30, a resolution laying before the House of Representatives articles of impeachment against Ronnie Lee Goldie Jr., Commonwealth's attorney for the 21st Judicial Circuit, consisting of Rowan, Bath, Menifee, and Montgomery counties. Representative Elliott.
Thank you, Mr. Speaker. And with that, I would move passage or adoption of House Resolution 30 at this time.
Question before the body is passage of House Resolution 30, the articles of impeachment attached thereto. Is there any discussion? Seeing none, the clerk will sound the chimes. Those in favor vote aye. Those opposed, nay. Roll call is open for your vote. Does any member wish to change or explain their vote? Clerk will take the roll. Being 97 members voting aye, no members voting nay, House Resolution 30 is passed.